Wicks versus Farmingdale is a matter where a teacher had exemplary, fantastic evaluations from the superintendent, but the board still withheld an increment. Why would the board do that? Well, 2 years prior to the withholding, after the evaluations were done and handed in, and the board had approved employment for the following year, this particular teacher, Ms. Wicks, had an incident involving grades with the students, and her grading of the students came under fire. She was criticized for the way she was handling or not handling that grading situation. But it was after the evaluations were done, and the board did not take action against her. The following year, again after evaluations were done, Ms. Wicks got into a confrontation with a parent, a verbal altercation that required some interventions. And of course, the board wasn't happy about this altercation with the parent. But the superintendent had already put the evaluations in, and the superintendent felt that even though she had the altercation, it was after the evaluation period, so he was going to go ahead and recommend her for a raise for the upcoming year. The board said, wait, this is 2 years in a row. We can understand 1 year where you have a situation, but 2 years in a row, no, superintendent, sorry, we're going to disagree, and we're going to vote to withhold her increment. And that's what the board did, was withhold Ms. Wicks' increment. So Ms. Wicks and her union appealed, arguing that the board couldn't, number one, override the superintendent's recommendation of the advancement on the salary guide, and number two, that the board couldn't take into consideration something that happened 2 years ago. Well, the commissioner said actually the board could take something into consideration from 2 years ago if it reflected on her overall teaching capacity. And here, bad judgment with the grading scenario and bad judgment with the verbal altercation with the parent did reflect on her capacity as a teacher. Therefore, the board wasn't being arbitrary, capricious, or unreasonable when it looked at the past 2 years of her conduct, and the board was allowed to withhold that increment. Now, the next case also involves a withholding. And this case is a little more problematic because in Trenton Board of Education versus the Trenton Education Association, we have a teacher who was having some difficulties earlier in the year. It wasn't getting his lesson plans done, it wasn't holding grades properly, was having some classroom management issues, so he needed a little bit of mentoring. But fortunately, the teacher took the criticism to heart and did improve his performance. Things went well for the latter half of the year. Despite the fact that the teacher's performance improved, the board still decided to withhold his increment. And that withholding clearly was challenged before the arbitrator. Arbitrator said that here the board made a mistake. When it withheld the increment, it didn't have an ending date on that withholding. It didn't put a stop period. It said we'll withhold the increment this year, and maybe at some point in time a future board will restore that increment. But that's the way an increment withholding works, because when the board withholds that increment, the reason they do so is because they want the teacher to improve his performance. And there's an expectation that if the teacher does improve his or her performance, then at some point in time a future board can restore that withholding. But that's entirely up to a future board, which is why there is no termination date on that withholding. Despite the fact that this has been the rule in New Jersey since forever, this arbitrator said, no, that penalty of an indefinite withholding is too harsh. Well, the board argued that they couldn't restore the increment. Well, they could have restored the increment this year, but that wasn't really a punishment. That's not a withholding, that's kind of just a delayed salary. So the teacher would get the full salary during the course of that year. And they couldn't state a date in the future to restore that increment because that would infringe on the authority of a future board, which the present board can't do. That's a decision for the future board. Here, the arbitrator said, despite the fact that the board had a valid basis for the withholding, the indefinite withholding was too harsh a penalty. Therefore, the arbitrator took it upon herself to restore the increment and ordered the board to repay that lost salary at the end of the year. This matter went before the appellate division, and the appellate division upheld the arbitrator. So we have a new rule on increment withholdings in the state. That was at least surprising, if not shocking. Now, certificates of vega. Sometimes boards find themselves in a situation where they've hired a bunch of teachers, and in September, a teacher or so will find a bigger, better deal and not show up to work, move on to a different district. If that happens in your district, board members sometimes don't know or have never been informed that if that happens and the teacher does not give 60 days notice, the board can actually file an action before the Board of Examiners to withhold that teacher's or suspend that teacher's certificate for up to 6 months. And that's what happened here in certificates of vega, is the teacher did not provide the proper notice, and the board actually went after her certificates and was successful in having that her teaching certificate suspended for 6 months. So a little bit of leverage that boards have over teachers if they find themselves in that situation. Also, next case, real quick, Cummings versus Egg Harbor, Little Egg Harbor. We have a teacher who was having, again, some difficulties. Was actually seen napping during faculty meetings. And not just, a little head nod here and there. We'll have a little cat nap or have some difficulties paying attention at the end of the day. She was actually knocked out sleeping. She was so well far into her nap that people were taking pictures of her. Not a good look. Also, this teacher happened to be in the office toward the end of school one day and overheard a phone call that a clerk was having with a parent. Parent said that she wasn't coming to school to pick up her child because she had a really bad hangover and was going to be late. So this teacher, overhearing the conversation between the clerk and the parent, told the clerk to call DYFS and get DYFS involved. Then kind of walked off and didn't tell the building principal or report to any administrator that she ordered the clerk to call DYFS. So you know what happens when DYFS shows up, or DCP&P I should say, Child Protection Services. They do a full-blown investigation and it turned into a huge thing. So because the teacher was sleeping during faculty meetings and made a really bad judgment call to call DCP&P, the board required her to undergo a physical examination. Because whenever a teacher evidences a deviation from normal mental or physical health, the board has the right to order a physical or mental examination. And that's what happened here. Now, I don't want you to think that it's just that easy as saying, here, go get an examination, go see our doctor, because the teacher also has rights. The teacher has the right to object. The teacher has the right to go to his or her own doctor to provide a counter opinion, which they usually do, because the district doctor, physician will show some type of deviation. The individual's, the teacher's personal physician will say, no, everything is fine. So you usually have to go to a third independent doctor to make a determination and get a third independent judgment. And of course, who pays for all of this? Well, the board has to pay for all this. So yes, you can remove people and have them either go through an examination or take further steps against them. But it's, there are a lot of hoops that you have to jump through. Tassoff versus Pleasantville. In this next case, Tassoff versus Pleasantville, deals with the sick leave bank. And some board members may be involved in the sick leave bank, may be on the committee. And if you're on that committee, you want to make sure that you follow all of the rules. Because in this case, Ms. Tassoff applied for leave from the sick leave bank and was denied. But the sick leave bank was late in notifying her that they were denying her that benefit. So when Ms. Tassoff reapplied, the committee again said no, but again was late in providing notice. So Ms. Tassoff did go ahead and take leave, provided documentation for a third time, And the third time the board said, okay, the committee said, yes, okay, we'll approve this leave. Even though the leave was 2 months ago, we'll go ahead and approve it. Now, we can't give you leave, and we can't pay you for the leave that we would have awarded you, but what we'll do is if you're sick in the future, we'll award you the right to use that sick leave in the future. Ms. Tassoff said, no, I don't know when I'm going to be sick again, or if I'm going to be that sick again, so I'd like to be reimbursed for the leave that I should have been given. The committee said, well, yeah, but we can't reimburse you. The statute doesn't allow for that. But the commissioner said, even though the statute doesn't allow for that, committee, you really should have followed the rules. You should have provided her proper notice, so we're going to allow you to, or order you to reimburse her for the sick leave that should have been awarded her when she was sick. So, little lesson, if you have that practice, if you have a sick leave bank in your district, you really want to make sure that you abide by the rules of the sick leave bank. Deach versus Camden County, Camden County Educational Services Commission. In this case, Ms. Deach's school district ripped her position as a media services specialist and outsourced her position to the Ed Services Commission. Ms. Deach filed a claim against the Ed Services Commission saying that my position was with the district, my position was moved to the Ed Services Commission, I was with my district, I'm not out of a position, obviously I should be in my position that is now with the new Ed Services Commission. Commissioner said, no, it doesn't work that way. You were never employed by the Ed Services Commission, so you don't have a claim against them. If you have a claim for the RIF, it's going to be against the district. You're suing the wrong people. So Ms. Deach had no claim, so apparently, unfortunately, she was out of a job. Next case, certificates of Gafrida. In this case, Ms. Gafrida was teaching a newer teacher in district and was very friendly with some of her male colleagues. In one case, giving them a hug, another case, a kiss on the cheek, another case, a little inappropriate touching was going on. When her male colleagues complained about this inappropriate contact, Ms. Gafrida apologized and said, you know what, I'm sorry, I'll voluntarily resign, and resigned from the district. A complaint was filed, but nothing really happened with it. So 8 years go by, and the complaint is revived. And during that 8-year time span, Ms. Gafrida had gone to a new district and hadn't had any issues whatsoever with anybody. But when that complaint was revived, the commissioner said, even though it was 8 years ago, and even though you've been a model employee at this new district for 8 years, and even though you voluntarily left, sexual harassment is sexual harassment and is not to be tolerated. So that 8 years of good behavior didn't warrant any lessening of the penalty for Ms. Gafrida. She did have her certificate revoked based on her sexual harassment of her colleagues.
There's no statute of limitations or anything?
You think there would be, but in this case, no. The case was actually filed timely, but administratively, one judge had the case for a number of years. It started the case and then resigned or retired. It was handed to another judge who backburned it, and I think it was handed to a third judge. So that's what happened over that 8-year time span. It just never got processed. So unfortunately,
Well, due process,
right, justice delayed is justice denied, right? But in this case, it was extremely delayed. Now, Middle River Board of Examiners, you've got to actually fulfill the requirements to obtain your certificate. That's obvious, so I'm going to move past that one. Certificates of Carroll, because I am running late on time. If you're going to file just an order of advice to individuals who are filing for a certification, teaching certification, and for board members as well, if you file false documents with your application for a certification, that fraud is going to be held against you if anyone finds out. And in this case involving Carol, she filed a letter of recommendation from one of her professors, which was false. On a reference check, the professor said, that's not me, I didn't write that letter. Obviously, the examiners found out about it and denied the certificate. So you don't want to have, or revoke the certificate, you don't have someone working in your district who's going to lie about their eligibility. So that's maybe one of the questions you want to ask if before the person was hired, they were properly vetted and their credentials were checked. Next case, the tenure arbitration of Odiasi in Newark. A very simple lesson here. There was a case of inefficiency, and the administrators in Newark did not come up with a corrective action plan for the teacher. They decided to rely on the teacher's professional improvement plan. The arbitrator in this case said, no, you can't rely on the teacher's professional improvement plan because the corrective action plan is designed specifically for the inefficiencies that have been identified in the evaluation process. The professional improvement plan isn't targeted that way. Therefore, there are two different documents. You can't rely on one to do the other's job. So if in your district you're going through inefficiency charges, you want to make sure to ask administration whether the teacher has a specific corrective action plan to address those inefficiencies. And if not, then administration really should have that in place. Tenure arbitration of Porter is a wonderful case because in this case we have a teacher with 27 years of experience and not a blemish, not a mark on his record. Teacher is a basketball coach, teacher is a mentor, and is loved by the community. Teacher sees a student who's kind of shy, kind of withdrawn, and figures, well, I'm the assigned mentor, I'll go ahead and mentor this student. Gets the student involved in basketball, is actually helping to draw him out of his shell, and the student's doing well. But Mr. Porter says, I can do a little bit more with the student. Goes to the student's parent and says, I know basketball practice sometimes run late. Would you mind if I brought the student home personally instead of having him wait for the bus, or it'll just be much easier, much more convenient for you? Mother, not speaking English, agrees. So Mr. Porter starts taking the student from basketball practice to the student's home. Except on at least one occasion where Mr. Porter didn't take the student to the student's house, Mr. Porter took the student to Mr. Porter's house. And at Mr. Porter's house, Mr. Porter put what he called blessed cream on the student's back because the student was sore, maybe? Not that the student had any injuries, but Mr. Porter felt that this blessed cream would help. And then transport the student home. Now, no allegations of any misconduct, no allegations of any wrongful touching or anything like that, but when the board found out about this, they were not pleased. They were really not happy and sought to terminate Mr. Porter by filing tenure charges. Tenure charges go through. The arbitrator says, well, there's no evidence that there was any inappropriate touching. And Mr. Porter's got an unblemished 27-year career in the district. We're not going to punish him for that one mistake with a blessed cream. We're going to put him back in the classroom. But we're not going to let him mentor any more students. So this teacher was placed back in the classroom, despite the board's best efforts to protect its students, which is what board members are really supposed to be doing, right? The arbitrator overruled the board and put Mr. Porter back in the classroom. And it begs the question, with the new sexual assault statute being extended and giving people additional time to file claims against their harassers or their employers, they have to wonder whether this case might show up in 10 or 15 years where there is an allegation that there was some sexual touching going on. And if that's the case, will Mr. Porter be held liable, or will the district be drugged into the situation?
What about the arbitrator?
Yeah, what about the arbitrator? Good question. So we'll have to see. A couple of really quick cases on inappropriate language. In Hoskins, Milwaukee, is how I'll mispronounce that. We have a teacher who was allegedly using profanity in front of students. Students were offended, and one student, as you can see, had to leave the classroom. But in this case, when administration spoke to the students, they got statements from the students, but the administrators wrote down what the students said. Didn't have the students sign it, didn't date it, but wanted to admit that as evidence that the teacher had engaged in profanity and misconduct. Yeah, Hoskins Nwake said, yeah, well, I didn't do anything wrong, plus there's no evidence against me. Now, no one wants to have a child go to court and testify, because that's one of the worst things you want to do. It's traumatic to testify against a teacher. You want to protect them against that. But at the same time, if you're going to file charges against the teacher, you have to have credible, sufficient evidence. And there's a way to get that evidence without traumatizing the student and documenting that evidence for use in an arbitration or hearing. So if that's going on in your case, you want to talk to administration to make sure that your administrators understand what those techniques are, or limit the questioning to appropriately trained individuals, because you don't want to have a case where you should be getting rid of a teacher, but you lose on an evidentiary standard. So it's just a training piece.